In today's video, I want to take a look at something that catches people out time and time again, especially employees, and especially employees who wouldn't be all that familiar or used to bringing legal claims or time limits, that sort of thing. So today I want to look at the time limits for bringing most employment-related claims to the WRC or the Labour Court. Hey, it's Terry Gorry, and this is the Terry Gorry Podcast. By and large, the time limit for most claims is 6 months. So it's 6 months from the date of contravention. You go forward 6 months and you must bring your claim within that time period. And if you don't bring it within 6 months of the contravention of the act of contravention that you're complaining about, then you're going to have a hard time having your case heard. Now, that's not to say that it's not possible. It is possible to get an extension of time from 6 months to 12 months. But the adjudicator, in order to look at that and give you that extra 6 months, must look at whether you have shown reasonable cause or not. What is reasonable cause? That's a reasonable question. Bottom line is that it will vary from case to case, but there has been quite a lot of decided cases in the WRC and indeed in the Labour Court about what is reasonable cause. The question has also been looked at in the civil courts. The most significant case, though, I think from the Labour Court and WRC perspective, is a case involving Cementation Skanska versus Carroll. Now, there's a number of cases there that I have put links to in a blog post that I've written. It's on employmentrightsireland.com on my website there, and you can have a look at that, have a look at the links. But essentially, if you're concerned about the time limit, if you're concerned about being late, if you're concerned about having to make an argument that you are entitled to the extension of time to 12 months, if you're concerned about showing reasonable cause, the takeaway is that reasonable cause involves you showing reasons for the delay, which one, explain the delay, and two, afford a justifiable excuse for the delay. So an excuse for the delay, not bringing your claim within 6 months, is not like the dog ate my homework, or it's not like I hung on as long as I could and I wanted to make sure that I had the best case possible, or it's not that I held out because some lad told me or some lad didn't tell me. It's not that I didn't know the law or didn't understand the law. There's nothing to stop you from going to a solicitor and getting advice. There's nothing to stop you from going to Workplace Relation or to the Citizens Information Service and getting free advice. There's nothing wrong with, or no problem going to FLAC and getting some free legal advice. Bottom line is, ignorance of the law is no excuse. By and large, you have 6 months to bring a claim for most employment-related claims. That can be extended if you can show reasonable cause to 12 months. In order to show reasonable cause, you must be able to A, explain the delay, and B, that the reason you're putting forward is reasonable and that it affords a justifiable excuse for the delay. As I say, this issue has been looked at by the WRC, it has been looked at by the Labour Court, it has been looked at by the civil courts, including the High Court in Donald O'Donnell and Catherine O'Donnell versus Dunleary Corporation. And the whole question of reasonable cause, good reasons for a delay, justification for a delay, justification or good reasons, reasonable cause for missing a deadline in terms of a time limit, they are all issues that have been looked at before, and you do need to be very, very wary of them. You will not automatically get an extension of time from 6 months to 12 months. You do need to show reasonable cause. I hope you find this video useful. The blog post, though, that I've referred to in the video, you should have a look at as well. It's on my website, employmentrightsireland.com. I'll put a link underneath this video. Take a look There's a number of cases referred to there, but the most important one, I believe, is the cementation Skanska versus Carroll case. That's a Labour court decision. It goes through the various authorities and looks at the various aspects and factors to be considered when looking at and deciding upon the question of reasonable cause.